In February of 2021, Joe Biden had been president for less than a month. The United States Senate was still in the middle of impeaching the previous president for stoking insurrection. The House impeachment managers, all of them Democrats, were making the case that even though Trump was no longer president, he had to be impeached because otherwise future presidents would be free to commit any crime or misdemeanor as long as they did so right before leaving office. And to rebut that, Trump's lawyers offered this counter-argument.
If my colleagues on this side of the chamber actually think that President Trump committed a criminal offense, and let's understand, a high crime is a felony and a misdemeanor is a misdemeanor. The words haven't changed that much over the time. After he's out of office, you go and arrest him. So there is no opportunity where the President of the United States can run rampant in January at the end of his term and just go away scot-free. The Department of Justice does know what to do with such people.
After he is out of office, you go out and arrest him. The Justice Department knows what to do. That's from Trump's lawyers. In other words, there was no need to impeach a president after he left office because the Justice Department would bring criminal charges against him. And that logic was apparently so convincing for Republicans that the #1 Republican Senator Mitch McConnell cited that very argument in his speech, explaining why he would vote to acquit Trump in the Senate impeachment trial.
President Trump is still liable for everything he did while he was in office. Didn't get away with anything yet. We have a criminal justice system in this country. We have civil litigation. And former presidents are not immune from being accountable by either one.
Trump did not need to be impeached. Congress could acquit Trump in the Senate because the criminal justice system would take care of all of it later. That was the logic Trump's lawyers and Senate Republicans relied on. Today, Donald Trump's lawyers went before the D.C. Circuit Court of Appeals to argue the exact opposite. They argued that Trump cannot be prosecuted for anything he did as president and that the only way to prosecute a president for crimes committed during his presidency is impeachment.
I understand your position to be that a president is immune from criminal prosecution for any official act that he takes as president, even if that action is taken for an unlawful or unconstitutional purpose. Is that correct?
With an important exception, which is that if the president is impeached and convicted by the United States Senate in a, proceeding that reflects, widespread political consensus.
You see, it's a shell game. Congress impeaches Trump for trying to overturn an election, and his lawyers say, no. This is a job for the criminal justice system. The criminal justice system charges Trump, and his lawyers say, no, sorry, this is a job for Congress and the impeachment process. At one point, Judge Florence Pan tested that theory with a hypothetical for the history books.
Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is no.
My answer is qualified yes. There's a political process that would have to occur under the structure of our Constitution, which would require impeachment and conviction by the Senate.
Trump's lawyer actually argued in court today that Trump could send SEAL Team 6 to kill a political opponent, and absent an official impeachment and conviction, there is nothing the U.S. criminal justice system could do about any of it. It is a shocking position to take, especially when you consider the number of times Trump has toyed with the idea of killing his political rivals, accusing General Mark Milley of treason, punishable by death, encouraging a mob as it rallied to hang Vice President Mike Pence, announcing that he could shoot someone, anyone, on Fifth Avenue. So, history happening here in this courtroom, maybe some prognostication, too. Now, President Trump was in the courtroom today, just feet away from special counsel Jack Smith. Trump was surrounded by his lawyers and by his body man, Walt Nauta, who is, of course, Trump's co-defendant in the Mar-a-Lago documents case. By all accounts, the judges here appeared more receptive to the prosecution's arguments, but Trump and his lawyers may not really have been there to convince the judges anyway. For them, the point may have been the hearing itself, delaying Trump's criminal trial, even if it meant explaining the hypothetical immunity and sending commandos to assassinate your political rivals. Joining me now is former U.S. Attorney and senior FBI official Chuck Rosenberg. Also with me is former senior advisor to President Obama and co-host of Pod Save America, Dan Pfeiffer. Gentlemen, thank you for being here. Chuck, I was astounded, and not in a good way, by what was said by Trump's legal team today in courtroom. Was there anything that they said that struck you as particularly meritorious?
No.
Full stop.
But I wasn't astounded because they were very clear about what they were going to do. In an appellate case, both sides file briefs. The judges read the briefs, the judges' clerks read the briefs, and nerds like me read the briefs. And so the things that the Trump team argued today were all in their brief. I think they made a strategic and legal mistake, Alex, by taking that absolutist position that you just described.
Yeah.
So, no, I wasn't really surprised today. I think that's the corner that they painted themselves into.
Dan, are you winning when you are arguing that the president can order SEAL Team 6 to assassinate your political rivals and there's no necessary punishment for that?
I recognize we're living in the political upside down these days, but you're definitely not winning if you're sitting at the defendant's table during a felony criminal trial to try to violently overturn the country.
True. But I do, I mean, I think, and I know I'm loath to say this because we're talking about Donald Trump, Dan. It feels like the articulation of a strategy of ultimate and total impunity, even in a situation where commandos are assassinating rivals, feels like the crossing of a certain Rubicon, even for Team Trump. Do you think it's resonant, this scenario that's been outlined, especially given the president's past history on statements relating to assassination?
Well, I mean, we should stipulate that most people are not going to follow what's happening in this court case. Most people haven't tuned into this election yet. But what I think is happening is Donald Trump, ironically enough, rose to power in 2016 by dominating attention. And he resurrected his political career by being absent from attention. Most of the public has not seen or thought about Donald Trump. And by sitting at the defendant table, by having these high-profile hearings, by the speech President Biden gave, he is reminding people why they were so uncomfortable with his temperament, his corruption, his authoritarian leanings in 2020. And so it's not there as the specifics to this, it's that Donald Trump is returning to center stage and highlighting some of his greatest vulnerabilities at this moment in time when people are starting to wake up and pay attention.
Yeah, fair enough. Chuck, there's the sort of legal aspect of all of this, beyond the actual question of presidential immunity. There is the potential, the litigation of all of this has the potential to significantly delay this case, which is seemingly Trump's ultimate end goal here. Can you talk a little bit more about how meaningful that delay might be?
Sure. So this trial right now is scheduled for March 4th.
Yeah.
And I think that date, Alex, is endangered, perhaps not doomed, but certainly endangered. Every defendant benefits by delay.
Yeah.
And Mr. Trump has opened to him some avenues to try and incur even more delay. It's not clear to me that the D.C. Circuit Court of Appeals is going to take a long time to decide this case. I think it's relatively easy and in the government's favor. But then Mr. Trump could ask for a full panel hearing, the entire D.C. Circuit, to hear it en banc. If he loses there, he could ask the Supreme Court. And there's no guarantee that the Supreme Court will hear it either, but you can ask. And so the more that Mr. Trump does these things, the more that he stretches out the timeline, it puts the government at a disadvantage. I still think this case can be tried before the election. I'm not convinced it'll start on March 4th. I think it's a remote possibility, but I think they can get it done.
I want to bring, for folks who have not followed closely the hearing that unfolded today, Judge Karen Henderson, one of the three appeals court judges, had this to say about tangentially the scope of presidential duties. Let's just take a listen to what she had to say.
I think it's paradoxical to say that his constitutional duty to take care that the laws be faithfully executed allows him to violate criminal laws.
What she's getting at here is basically the scope of what is official duties for the president.
That's right.
It feels like that's actually a question that could, beyond the immunity question, could be sent to another court to decide and delay this in an even more meaningful way than just the back and forth between the en-banc hearing at the appellate court and the Supreme Court.
And by the way, if Mr. Trump's lawyers had not taken an absolutist position, this is the logical argument for them. They could have said, sure, there might be a circumstance under which a president or former president could be prosecuted criminally, but this one ain't it. All they had to do was argue that what he is charged with in the underlying indictment was an official act. And then it's not an enormous leap to claim immunity for official acts. But they didn't do that. To your earlier point, they staked out this absolutist position, painted themselves in the corner. And of course, Judge Henderson or another one of the judges was going to ask precisely that question, because that's the fallacy, that's the weakness in their argument.